Okay, so normally I like to walk out, but I've been told I can't because we're recording this, so I'm going to be stuck behind the lectern. I'm going to have to yell at you, but things you have to do anyway. So thank you for coming. I'm really glad to see some faces. I was just saying to someone, I'm tired of looking at a computer screen. So thank you all for making the effort to come in this morning. It's so good to actually have you in the room and see real life people as opposed to just seeing a blank screen. So thank you very much. You've got in front of you a copy of the PowerPoint, so hopefully you won't have to take too many notes. You'll see it's quite thick. Quite a few things have been happening and are happening in our world. So I've tried to cover as many of those changes as possible. If at the end of all of this you still aren't certain about something or you want more information, by all means, come up and see me afterward, and I can actually then, if you give me your email address, I can actually email you more information. It's too hard to obviously go into a lot of detail about absolutely everything. And I'm also conscious that some are charities, some are not-for-profit, some are companies, some are incorporated associations. So there may be parts that don't directly apply to your organisation, but may apply to someone else. So it's going to be a bit of a Kontiki tour this morning. I'm just going to go from thing to thing to thing. At the end of it, you may feel like you got a hangover, but you walk away thinking, I still had a good time, right? All right, so firstly, I will try to keep this short. I appreciate you've all got to get to work, but by all means, hang around afterwards and have a chat with me if you've got the time. And also feel free to interrupt me as I'm going through if you've got any questions. So let's get started on the first of many topics. So this is a list of things we're going to cover this morning. We're going to be looking at virtual meetings, DINs, DGR laws, PBIs. There are some new changes coming in for those of you who aren't charities but are income tax exempt not-for-profits. There are some other changes coming in for registered charities, a little bit about fundraising in New South Wales, and then we're just going to finish off with only one slide about public ancillary funds. So virtual meetings. This mostly applies to companies, but there are some changes that have been made for incorporated associations, especially those of you in New South Wales. And I think the principles apply the same regardless of whether you're a charity or incorporated association. So virtual meetings up until COVID were not permissible for companies or incorporated associations. The idea being that the law was of the opinion that you need to have at least 2 or 3 people in a room to actually have a meeting. And then COVID hit, and of course, there was all sorts of angst about how we're going to have our AGM, how we're going to have a meeting when we can't actually physically be in the same room. So ASIC decided that for companies at least, they'll temporarily change the laws to allow virtual meetings. And by virtual, I mean effectively everyone's doing it from home. You haven't got any sort of central location at all. There's no address given in the notice. You're just given a link and people connect that way. That's different from a hybrid meeting, which has always been allowed, which is where you still give an address and people who want to physically attend can attend, such as what we're doing this morning, but people have the option of also joining in from home online. So that's always been allowed, but obviously we couldn't even do that when we had the restrictions. And so virtual means no one's in the same place. Everyone's actually connecting online. So ASIC decided to make it easier for companies to comply with all of their obligations to have meetings, especially AGMs. And so they temporarily allowed virtual meetings, regardless of what was in your constitution. So even if your constitution didn't mention anything about virtual meetings, which would normally mean you can't have them, ASIC overrode that through changing the Corporations Act and said you can actually have virtual. Now, if you're a charity, that's a company, that doesn't apply to you because those sections of the Corporations Act which were changed to allow virtual meetings already switched off for you, right? So that means if you're a not-for-profit and a company, you can have virtual meetings. If you're a charity and a company, those changes don't benefit you at all. So again, you're relying on your constitution. So I saw quite a bit of activity over the last, say, 12 months where companies were saying to me, we want to change our constitution. We want to actually put it into our constitution that we can have virtual meetings. So therefore, we're not depending on whether the law's allowing it or not allowing it. We're not depending on these temporary arrangements and the like. So these temporary changes only go up to the 31st of March 2022. So we've got another 4 months or so. And that is the case regardless of whether you're a company or an incorporated association. I'm going to get to the permanent changes, right? And again, to make it easier, ASIC introduced some temporary arrangements about how companies sign documents. So if you've got a company and you want to sign a contract, normally you do it under Section 127 of the Corporations Act, which means you need 2 directors' signatures or a director and a company secretary. Obviously, again, that was hard during COVID, and so the Corporations Act was changed to allow electronic signatures to be applied. That is still the case. There are a couple of rules around that, in that the copy being signed by the director or the secretary has got to be the whole document, not just one page. And there's got to be some way of identifying the person who signed and the fact that they actually wanted to sign. So this is obviously to avoid a director secretary applying the electronic signature without the director knowing. So as I said, that was for companies and associations, at least in New South Wales. So to repeat, incorporated associations in New South Wales, you can have virtual meetings up until the 31st of March, regardless of what's in your constitution. Again, I would recommend the next time you review your constitution, just put it in as something that you're allowed to do. And the law also changed the way people can vote to allow electronic ballots, again, to allow people to vote virtually. So all of that is in place until the 31st of March next year, and we don't know what's going to happen yet after that. Yeah.
So are you saying that the charities then it was not legal to have an online meeting?
The ACNC sort of filled the gap and said that if you're a registered charity, because you don't benefit from these changes happening in the Corporations Act, they will effectively adopt a policy in that they'll overlook the fact that you're doing it virtually. So it wasn't actually a change to the law, it was just a position that they took to allow charities to do the same thing.
Not had 2 virtual meetings.
Yeah, yeah. So it was a policy, not a law. And again, I would recommend, next time you look at your constitution, put that in.
Yes.
Yeah.
When you say next time you look at your constitution, you're recommending that we all update our constitutions in the next 12 months?
I would. I mean, obviously, I would. My mantra always is you should be looking at constitutions regularly to make sure that they're up to date and you're making necessary changes. So I would have thought that at least once a year you'd be sitting down looking at it and making those changes. Some organisations have just said, look, we just want to do it now, and they've just gone ahead and done it. But I wouldn't be waiting another 12 months. And again, look, the law is there at the moment, it's allowing you to do it, but there is some certainty in having it in your constitution where regardless of what ASIC is doing or not doing, you can do that. All right, so what do we do if we want to do this properly? Your notice of meeting, the document you send out telling your members you're going to have a meeting should have enough information in there to allow members to work out how they're actually going to connect, and also some information about how they're going to participate, right? Also, your technology is such, or has to be such, that it allows people to participate. So they've got to be able to ask questions and to be able to talk to each other. Now, I've read that some of the more resourced not-for-profits, which can afford to do this, they will get proper technology in. They'll do a test. If they're having an AGM, which is a serious meeting, they'll do a test run beforehand to make sure the technology is working. And during the meeting itself, they have IT people on standby in case there are any sort of technical issues. You don't have to have any of that. It just depends on what you're able to do. But you've got to be able to show that when you organise the meeting, you made it available to everyone. It was easy for people to be able to log in, and people were actually shown how they can actually participate. You can't have people just logging in and then not being able to say anything or communicate in any way. And I would recommend that even though this is technically for companies, incorporated associations should follow the same principles. It is important to know that if during your virtual meeting a member has difficulties connecting, or they did connect and they, something happened and they lost their connection and they can no longer participate, it doesn't mean that your meeting's invalid. So don't be concerned about people subsequently saying to you, well, I had some sort of technical hitch and I couldn't participate after the first 10 minutes, and they want to then question whether or not the meeting that went ahead without them was valid. That's not a concern, right? So long as you did your best to make that available, what happens after that doesn't cause you any legal issues. Further, if you need to table documents at all at a meeting, I mean, obviously, if you have people in the room, you just hand out printouts. That's hard if it's virtual. So all you need to do is either make those documents available before the meeting or at the meeting electronically. So you either email the documents out or you give them some sort of link to allow them to access the documents online. So we're talking about at an AGM, financial reports, directors' reports and the like. You can make all that available electronically. However, members, especially with notices, members can actually say, I prefer a hard copy, in which case you have to do your best to try to make that available.
Can you screen share? Is there any sort of thing about, because what if there's a last
No, that's fine.
change or anything like that? So screen share is absolutely fine.
Yeah, yeah. But if I was to say to you afterwards, can I have a copy?
Yes.
You should make it available. Yeah. And they also recommend that if you're going to have any voting at the meeting, that you do that by way of poll, which means you count, unless your constitution prohibits it. So you'd have to think of, if you're going to vote on, say, changing a constitution, how you're actually going to count the people. Now, this can be confusing because you'd have to know, with all the people who sign in, who of those people are actually voting members. Make sure you've got your quorum. And then when it comes time to vote on a resolution, you need to be able to calculate how many people voted for or against. And then out of those people who voted, you need to work out, did you get 51% for an ordinary resolution or 75% for a special resolution? So always make sure that you can distinguish in your mind the difference between the people who've logged in versus the people who actually are allowed to vote versus those that actually did vote. Does that make sense? So if I had all of you logged in, but only 15 of you are allowed to vote, only focus on the 15, I make sure I have my quorum. But if out of the 15, only 10 of you voted, then when it comes time to work out was the resolution passed, I focus on the 10 and I work out who voted for or against. As I've said before, you need to be able to allow members to speak and ask questions. That's orally and in writing. So you need to have some sort of chat room on the side where people can type in, but also if people want to be able to ask something, you need to make that available. I've noticed in webinars recently, the presenter is speaking and everyone else is blocked from talking, from turning on their sound or even their videos. So videos is not as important, but in a meeting of members, you can't block them. They've got to be, you can set rules about how you're going to manage what people say and when they say. You've got to be able to somehow control that, but you can't just block them off from an audio perspective and ask them to just type things in. You can issue notices electronically, which means obviously by email or even, I guess, in a link to your website. But as I said, if a member says to you, I really prefer a hard copy, you've got to make that available. You don't have to tell them that they're entitled to a hard copy if you don't want to, but if they do ask, you've got to somehow make that happen. Now, as I said, these changes until the end of March next year, there is a move to make them permanent, obviously, because that's the way the world is heading. So there was a new bill introduced in October to make these changes permanent. So that would include electronic signing of documents, sending notices electronically and holding virtual meetings. That is yet to become law, but there is a move to make that happen. So for those of you who think it's just going to be too hard to change our constitution to allow this to happen, if you hold out to when it becomes permanent, you make it the same result.
From the signing of documents, the actual signing of the document is standing.
Yeah. I had to do that the other day where I had 5 organisations signing the one document and we agreed with each other by email. We're all going to accept scanned signatures and then we managed, and it was just so much easier.
Maybe we stand one for each.
Yeah. or you don't even have to do that. You can, instead of the round robin where it goes from party to party to party, you can get them each to sign their own page and then you collate them. Yeah. All right. You would have heard about these director identification numbers. So that is an actual change to the Corporations Act, and that's already started, and it requires all directors of companies, and I'll tell you which companies, and future directors to obtain this identification number. So it's a, yes.
That doesn't apply to not for associations though, does it?
I'll get to that. Actually, I may as well say it now. It applies to all companies. It applies to all Aboriginal and Torres Strait Islander corporations, and it applies to any organisation, including an incorporated organisation, if you are registered with ASIC as a RAB, which is a registered Australian body. If you're not, if you're just a plain old incorporated association, you don't need one. Right. So this number has 15 digits, and it's your number forever. It doesn't change. It stays with you until you're gone. It is to stop fraudulent identities being created. So if I was a director of Mills Oakley Proprietary Limited, got myself into trouble, and ASIC banned me from being a director for the next 5 years, up until now it would have been quite easy for me to create an identity as someone else. I can fabricate my date of birth with it because there's no ID documents required to become a director. I create a new name, a new date of birth, and I become a director of another company the day after. And obviously that leads to all sorts of trouble. So to get around that, they've given each person this identification number, which you've got to quote, which obviously then means I can't then go and create a new identity next week. It is administered by the Australian Business Registry Services, which is a website, but it's regulated by ASIC. So there is a bit of a difference there. Now, what are the timelines? If you already are a director of a company, you've got until November next year. If you're going to become a new director, so you haven't been a director before, and you're appointed between the 1st of November this year and 4th of April next year, you've got a month after your appointment to get your number. And from the 5th of April onwards, if you're going to become a director, you've got to get your number before you get appointed. So if you are CEOs of not-for-profits, this is something you're going to have to manage. So think about how this is going to work, especially say if you've got an AGM and directors are being elected, right? If you've got an AGM in 2022 and you call for, so say I nominate myself, right? I actually, if I'm successful, I'll be elected at the AGM meeting. I'm a director pretty much from the moment I'm elected. But according to this, I should have given you my number before I got elected, but I didn't know that I was going to be elected, right? So you're going to have to manage this process to make sure they don't fall foul of these laws. So, sorry?
Sorry, I've been thinking about that. So AGM is in May and we've got 3 vacancies that will be needing to be filled. So I thought that in the call for nominations it would be stressed that you have to have.
Yes. Even though they may never get to be a director, they'll have to have their own number. So you'll have to include that as part of your paperwork and your preparation for your meetings if you actually elect directors at those meetings. Or even at board meetings, if you're appointing co-op or independent directors, make sure that's part of your process going forward. What are the offences under this new law? They're all included in the Corporations Act, and as I said, ASIC enforces them. There are fines, there's even imprisonment for fairly serious offences. And I wanted to let you know, because this wasn't all that easy to find, this is something that occurred to me, there's currently no requirement. So if I get my DIN, I don't at this point have to give it to ASIC. I got it through the ARBS. I don't have to give it to ASIC, and I don't have to give it to any companies of which I'm a director. Now, what's going to happen is at some point in 2023, so about 2 years from now, the register of companies that ASIC currently controls, you know, you can go and do a company search and it's all there, that whole register is going to be transferred across to this ARBS, right? So At that point in time, in 2 years' time, when that happens, then my number is going to be attached to all the companies of which I'm a director. So they're going to be linked, right? So at the moment, I don't need to do anything, but I'm guessing from then on, there's going to be some sort of reporting requirement as to how all of that happens. And if I were to be appointed as a director so next year I get appointed to another charity board, then obviously the charity board would want to make sure that I'm complying with these requirements. So they'll say to me, Vera, as I just mentioned at these AGMs, give us your number so that we can make sure that all the records are kept up to date. And obviously for me now, even if I change my address, because I've got this DIN, I'm going to have to then notify the ARBS, because it's got all my contact details, that I've now just moved house and I've got a new address. So it's just a whole other level of reporting that we're going to have to be on top of. This doesn't, sorry, yes.
And that reporting is responsible of the individual.
Of the individual, but I would have thought management would want to make sure that they're helping the directors be compliant. This doesn't replace any existing obligations I have as a director to keep ASIC informed of any changes. So again, if I move house, if I change my surname, I'd have to notify ASIC. All those requirements still say the same. So this is just an additional requirement. It doesn't replace any existing requirements. How do you apply? Listen, I did it. If I can do it, anyone can do it. So this should give you confidence. I did it a couple of weeks ago. And once I worked out what I was doing, I won't tell you how long that took. It literally only took a matter of minutes. But if you are a director who's resident in Australia, you got to do it through your MyGov ID app, which we know is different from the MyGov app, right? Which I already had. So I thought this would be easy. So I had to go through the ARBS website that somehow then took me to my MyGov ID app, which then asked me again for my tax file number and my superannuation bank account, blah, 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 which I knew I'd already put in before, but it asked me for that again. But once I put that in, it just spat out a number, which I've now got. So it's not overly difficult. You've just got to be prepared to have some of your supporting material available, such as your TFN and the like, to be able to plop that into the fields. All right, enough about that. Let's move on to some DGR laws. How many of you are DGRs? Okay, a few of you. All right. I won't spend long on this because it doesn't apply to everyone, but I still think it's worthwhile knowing. So these changes, which have now commenced, have been in discussion since 2017. It's only 4 years. Often it takes up to 10 years. So they're improving. It finally became law on the 1st of October, and it applies to deductible gift recipients. You'll know that you're a deductible gift recipient because it'll be on the ABN lookup website, and it means that you are able to receive tax deductible donations. What are the changes? The changes are that if you are a DGR and you're not connected to government, you should now be registered with the ACNC as a charity. There used to be, and still is, this whole group of DGRs out there which have never registered with the ACNC, but should have, right? And so now it's law that you have to be registered. There are some DGRs that are government connected. They can never be charities. So the Art Gallery of New South Wales is a DGR. If I make a donation, I get a tax deduction, but that's run by government. That can never be a charity. But there are many DGRs out there that have no connection to government, but have never bothered registered with the ACNC. And now it's been decided that you have to be. You either have to be registered yourself as a charity, or you've got to show that you're sitting underneath a registered charity. So that's what's just, actually it's going to start next Tuesday on the 14th of December. So that's a new change, and they've given people a year to get their act together and register. If you can't get it done in that year, you can apply for an extension, but hopefully a year should be enough. These next two slides are those that are most likely to be affected. but it doesn't mean it's limited to this list. And I called the ATO when this first happened, and I said, are you actually going to be notifying DGRs that they should be registered? And they said yes. So if nothing else, you should be getting some sort of communication, an email or a letter from the ATO saying, because of these new laws, you should be registering as a charity with the ACNC. So I'm hoping that no one falls between the cracks. And what do you need to do? Simple, you've got to actually apply to be registered with the ACNC. So there'll be an application form along with potentially some written submissions as to why you're eligible to be a charity. So it probably doesn't apply to any of you, but it is something that's been talked about for a long time, and I finally managed to get it across the line. So as I said, that starts next Tuesday. All right. PBIs, how many of you are PBIs? None.
Can you not copy my acronyms, please? Because I didn't know the other one.
Okay, so PBIs, public benevolent institutions, right, which is a special sort of charity. So out of all the different sorts of charities you can have in Australia, a public benevolent institution and a health promotion charity give you the best tax concessions. So many organisations will try to get registered as one of those two, and it's usually as a public benevolent institution. But it's not easy, as some of you in the room know. It can result, at least for me, in many trips to the hairdresser because of the grey hairs I get trying to get endorsement. It is, and in my opinion, even though the laws seem to be becoming more flexible, I think the ACNC is becoming more difficult in terms of actually approving charities as being public benevolent institutions. And it's funny, it's one of those sorts of charities where I'll get people calling up on the phone and saying, Vera, we want to be a PBI. And I'll say, okay, well, what do you do? I need to determine whether you're eligible. Now they'll say, oh, no, you tell us what we need to do and we'll do it so we can become a PBI. Right? So it's a very popular category. It has many, many benefits attached to it, but likewise, it isn't easy to get. So there was a case some of you would have heard of about called Global Citizen, which was handed down a few weeks ago. It's one of these landmark cases. There's been a lot written about it for those who are charity geeks, because it once again extends the law to allow even more charities to apply and get this PBI endorsement. So quickly, what was the situation? There was an organisation called, and it is still called, Global Citizen Limited International. It was an education and advocacy organisation trying to create this movement to end basically extreme poverty, and they did that through music concerts and other sorts of big public events to bring this issue to the fore so that the wider community, the public, was made aware of these issues that are plaguing the world. And in that way, they were trying to use that momentum to then be able to go and talk to various politicians and the like to say, you know, we are really serious about this. We need to do something to actually address the issue of extreme poverty. And that's the way they actually tried to relieve poverty. They applied to be a PBI, got knocked back. The ACNC refused. They said that Global Citizen was not providing direct relief. I mean, it's not your typical way of running a soup kitchen. People come in and you feed them or you give them sort of short-term housing. This is really at the other end of the spectrum where you can argue there's no connection at all between having a musical event and ending world poverty. So there was quite a huge gap between the two. And the ACNC said that gap is too huge for us to be satisfied that what you're doing is actually going to be effective in ending world poverty. The ACNC said what you're really trying to do is convince government and philanthropists and educate people about the issue of poverty, but actually not relieving poverty, which you need to be if you want to be a PBI. So they knew it was going to be hard to get the endorsement. They nevertheless applied because they wanted to receive distributions from ancillary funds. So let me explain that to you. An ancillary fund, you may have heard of it, is either public or private. It is where it's a pool of money. People make donations and they get their tax deduction. And that's called an item 2 DGR, an item 2 deductible gift recipient. By item 2, I mean It doesn't actually then do any work itself. It dishes out that money to other charities which are doing the work. So it's a foundation of sorts, right? And item 2 DGR, these ancillary funds can only give to item 1 DGRs, which are usually these public benevolent institutions. So Global Citizen was saying, we want to be able to receive funding from these foundations, from these ancillary funds. We can't do it unless we become a public benevolent institution. So that's why they applied in the first place. So the ACNC rejected their application. They would have then gone through some sort of internal review, and then they appealed to the Administrative Appeals Tribunal. And the Administrative Appeals Tribunal looked at what Global Citizen was doing to decide, was the ACNC right in rejecting it, or do we need to broaden our understanding of how charities work in the 21st century to allow these sorts of activities to be eligible for endorsement as a public benevolent institution? And the tribunal, in looking at all that, relied on a previous landmark case called Hunger Project. I don't know whether any of you have heard the Hunger Project case. Yes, no? No, okay. So the Hunger Project case was from 2014, and it was a landmark case because prior to then, if you wanted to be a PBI, you had to show the Charities Commission, or even before that, the tax office, that what you were doing as a charity was directly helping people in need. So you had to show that your activities were helping people who were sick, feeding the homeless, housing people, providing mental health relief, whatever it was. You had to show that direct connection. Hunger Project was different. Hunger Project was an organisation that only did fundraising. That's all it did. It had no connection with the people in need. It was just fantastic at fundraising. But it was part of this conglomerate of charities. And what it did was it fundraised to give money to the other charities, which were then giving the direct relief. So Hunger Project said, we are part of a bigger group. This is our role. We still think that even though they're only fundraising, we are still helping people in need by funding other organisations that do that work. And the court held that, yes, we have to be modern about this. We have to be open about this. That, you know, people are operating charities differently in this day and age than they used to. And this is a very effective way to actually provide relief. So the court said, yes, you can be a public benevolent institution. So that case was very relevant here because the ACNC was saying, we just don't see the connection between your advocacy, your education, your events, and actually relieving poverty. The Hunger Project was quite relevant. The tribunal looked at that and it agreed with the Hunger Project decision of 2014. And it said that our modern day contemporary meaning of what it means to be a public benevolent institution means that you do not have to directly provide relief. You've just got to show the trail. You've got to show the connection between what you're doing in collaboration with what someone else is doing and how you work together to then provide the relief. So we're broadening the way we do things, right? So the tribunal said that that Hunger Project case was clear authority as well. Not only that you don't have to directly provide relief, but you don't have to have what's called a causal link between what you're doing and the end result. What do I mean by that? You do not have to show that what you're doing as a charity is actually successful. You do not have to show, especially for Global Citizen, that their way of doing things through the events, through the advocacy, through the education, actually did reduce poverty. All you had to show was that was their purpose. Whether they achieved that or not cannot be held against them because there are things that we just can't do, but we're all trying to address a particular need. So the tribunal said you don't have to show some sort of success rate. You just have to show that what you're doing has the purpose or the goal or the aim of, in this case, relieving poverty. So in Global Citizen, obviously when you read the decision, for those of you who are sitting at home on a Saturday night and it's raining outside and there's nothing on TV and you, gosh, what am I going to do? Let me read the Global Citizen decision. or if you're suffering from insomnia. Obviously, in that decision, you can see the ACNC struggling with this and saying, well, hang on a second, this just doesn't sound right. This is not what a PBI is. And by the way, we've checked out Global Citizen, we looked at all their activities, we looked at their constitution, and we think that Global Citizen, you know, may to some extent be trying to relieve poverty, but it's got all these other independent purposes. It has an independent purpose of education and advocacy. The word independent is never a good word in the context of charity law or public benevolent institution law. They don't like independent, right? They don't like you doing a charitable thing and also then something different. You've got to show how somehow or other it is all connected, all your goals are connected, all your activities are connected. So the ACNC said, we've checked them out. Yeah, you know, they may be trying to relieve poverty, but what they're doing in terms of advocacy and education is independent. It is on such a scale, it's independent of relieving poverty. And because they've got those other independent purposes, they can't be a PBI. So the ACNC was really putting up a good fight. They said, again, we've looked at what Global Citizen is doing. Relieving poverty is not their main goal. It could be one of many goals. It's not their main one. And so therefore they can't be a PBI. The tribunal looked at that and the response was, the ordinary meaning of main in your objects clause in your constitution does not mean you can't have other objects or purposes, provided that your benevolent, it's got to be benevolent. Your benevolent purpose is the main one. This gets all really tricky and complicated, and this could, you know, you could write a thesis on this, which I'm not going to do because my life's too short. But, you know, it gets tricky. What's main, what's independent, what does sole mean, what does predominantly mean, and it's not an easy exercise at all. But the tribunal nevertheless is sort of broadening again the scope of the goals that a PBI can have, the activities that a PBI can have. So I think that this is good news because it should be easier then for some of those organisations, especially on the cutting edge of trying to address whatever need they're trying to relieve. It means it's more likely that they're going to be able to get endorsed as a PBI. So after all of this, the ATO went back to reading the Constitution of Global Citizen. You'll hear the word constitution many times this morning. I cannot overemphasize the importance of your constitution, right? Went back, read the Constitution of Global Citizen, said Global Citizen really only has one purpose. They want to relieve poverty. Everything we've looked at still comes back to this main purpose. They want to relieve poverty, and they use education and advocacy not as separate purposes, but to underpin and to carry out their main purpose of relieving poverty. I've quoted here from the decision, and the last sentence is most important, in that, you know, you're not lawyers, so you don't need to think about this, but, you know, sometimes people get confused with charity law and public benevolent institution law, and they think that the same rules apply. They don't. The tribunal said that a PBI does not have to have exclusively benevolent purposes. So it's really, when you're looking at whether or not you can be a PBI, you've got to look at everything. You've got to look at your constitution, you've got to look at your activities, you've got to look at it as a whole, and as a whole say, what is the main thing we're trying to achieve? And is that main thing benevolent? Is it helping other people? If you can prove that and everything else fits into that main goal, you should be able to get endorsed as a PBI. Yes.
Previously, I've successfully managed to get PBIs for organisations where maybe only 10 or 20% of their objectives were PBI relevant by setting up completely separate.
Yes.
But still associated with them. I'm about to start trying it for another 2 organisations. Again, the PBI relevant area would only be at the most 20% of their activity. Do you think it's worthwhile trying to get it for the organisation as a whole, or go back to the other approach of setting up a completely separate organisation that only has the PBI activity? So leave their own one there as it is.
Right, okay. I think if people had a preference, they'd always just want the one organisation for a number of reasons, one of which obviously is administrative, but secondly means that your donations coming in can be applied to anything, right? If you siphon off the PBI activities, then the tax deductible donations are only going to those activities and not what's being left over in the other organisation. So ideally, you should have one. And I think because these laws are emerging and expanding, your first port of call should always be, can we get PBI endorsement for the whole within this expanded definition? And then if it looks too hard, then restructure and separate out the PBI activities.
The other objectives, they wouldn't be allowed to use DGR donations for those.
Oh, right, okay.
objectives. So what I did previously was the new organisation, the members were only the board of the other organisation, and the board was automatically the board.
Okay,
of the
yeah,
other
yeah.
organisation.
And look, that,
Thinking of it, yeah.
and that works. Look, obviously there are different sorts of DGRs and different rules, but I would still, given that there is changes happening all the time,
Yeah.
I would still, as my first question, ask myself, is there a way of doing it within the organisation?
Yeah.
And if you can't, then by all means go and restructure. Yeah. All right, so this is fantastic in that the tribunal said advocacy, awareness raising, educational activities are common methods in tackling issues such as global poverty. So it's good to have that endorsed. And it found eventually that Global Citizen was an entity organised for, conducted for and promoted relief of poverty, despite their unorthodox ways of doing that. So once again, we see that the courts are trying to be more modern, more contemporary in their analysis of how charities are actually doing their work, and they're appreciating that many PBIs find the political process is not only a regular part of what they do, but indispensable. So it's good to have that as well. And last night I received, because I'm in the ACNC professional user group, I received a copy, I haven't read it yet, but I received a copy of some sort of statement or guidance, according to the Commissioner's interpretation statement, I don't know, from the ACNC about their interpretation of Global Citizen. And I think that's going to be made public in the next day or so. So wait for that to come out, because that will now be the ACNC saying we've now absorbed what the tribunal said, and this is how we're going to apply it. If you can't get hold of that, email me and I'll flick it across to you. All right. Another interesting case is this one of the Women's Life Centre from this year. Again, they wanted to be a public benevolent institution. They went to the tribunal and they failed. So this was the opposite result. This organisation provides counselling and other services to women experiencing pregnancy crisis. And as I said, they applied to the ACNC, got rejected. They went to the tribunal and the tribunal said, we agree with the ACNC. So the tribunal said that although the Constitution was well drafted in that the objects clause was a PBI clause, when the tribunal looked at the activities, they didn't line up with the clause, right? The activities weren't as focused as the objects clause was. So when the tribunal actually studied what this organisation did day to day, they weren't just helping women who had some sort of crisis pregnancy. Anyone who came up to the door and wanted help, I think it was, you know, pregnant women, got help. And the help that was provided wasn't really focused on helping crisis pregnancy, was much more general. So the lesson from this case is you can have the best drafted clause in your Constitution, but your activities need to support what you say in your Constitution. And let me tell you, the ACNC will look at everything, right? Anything that's public, they'll study your websites. I've had the ACNC come back and say, Vera, we loved your submissions, very well written, but we looked at the website and the website says something different, right? So until you fix that up, you can't get the endorsement that you want. And the ACNC and the tax office can come in to your organisation and say, we want to see everything. We want to see your policies. We want to see your promotional material. We want to see your internal documents. We want to see your processes. We want to check out everything. Everything that you do internally and externally has to line up with what you're telling the tax office and the ACNC. So I think that's something that we need to keep in mind. It's not just we've got to talk the talk, we've got to walk the walk and make sure that everything we do supports what our Constitution says we're doing. Okay. Are any of you not charities and you don't pay tax? This is just for you. Oh, we've got 2 people. All right. Okay. So up until now, you have had to self-assess your income tax exempt status, right? You have to work it out on your own and you have to be confident that you got it right. You could apply to the tax office for a private binding ruling, which is where you write to the tax office and you say, here's our Constitution, here's what we do day to day. Can you please confirm our assessment that we are income tax exempt? And they look at all that and they hopefully send you back a letter saying, yes, we agree, you don't have to pay tax. That ruling would last for 3 years and you'd frame it on your wall so that you never forgot that you had the ruling, right? But most not-for-profits, which aren't charities, just wing it. And many of them get it wrong. They're not paying tax when they should be paying tax. And there are others, God bless them, they're happy to pay tax and they don't have to be paying tax, right? So there was a lot of grey. So the tax office got some funding to start a new system for those not-for-profits. And from the 1st of July 2023, those income tax exempt not-for-profits will have to lodge with the tax office some sort of annual review where your board, I think your board should be signing off on this, but you can obviously have management included. The board will actually fill in a form to be able to tick off at the end, yes, we still think we are exempt from income tax. And then you lodge that with the tax office. The question or the questions I'm struggling with are, one, the fact that you've lodged this return and you still think you're income tax exempt, is the tax office going to look at that and agree with you? The fact that they don't come back to you, does that mean they've agreed and so therefore, yes, you are income tax exempt? I don't understand whether this is an exercise just to force not-for-profits to review regularly because you've got to submit something, or it's actually going to turn into some sort of endorsement by the tax office because they've received your review and they look at it themselves and they say yes or no. That I don't know. I wish it was the latter, but it may just be some sort of exercise to force not-for-profits to keep this front of mind, because many not-for-profits don't think about it or they only look at it every 2 or 3 years and they should really be looking at it annually. The last thing you want, let me tell you, is having the tax office knocking on your door saying, why haven't you paid tax for the last 3 years? Here's your tax bill and here's some interest and here's some penalties on top of it. And I've seen that happen. So is this going to be a good thing? I don't know. It just depends on how far they're going to take it.
It's only an issue if you change your purposes and change your objectives and change practices. Like most of us in associations that we use the benefit.
Well, yeah, well, yes, except that you need to appreciate sometimes the conditions attached to those categories change and sometimes the interpretation of those conditions change. People are going to court all the time and judges are issuing decisions about, well, that condition now means this, right? So generally speaking, yes, if you've always done the same thing and at some point you got proper advice that you were income tax exempt, you haven't changed much, you should be okay. But I can't say to you it's never going to change, and so therefore you just sort of go through a ticker box, approach. Yeah. What about charities? There's a lot happening here. So from the 30th of July this year, the ACNC charity register is supposed to include a link from the charity to its disclosure on the Australian Electoral Commission's transparency register, right? So if a charity has been making donations which are caught by that AEC register, it's now going to be much easier for the public to access that, because if they link into Homes for the Homeless Limited on the charity register, and Homes for the Homeless has actually made electoral donations, there's going to be a link now that takes you to that page, and so it's much easier then for the public to see where you're donating your money. And I think it'll be much easier for the ACNC to see, are you still complying with all the rules around advocacy? So This is to catch, I think these definitions are almost useless, but anyway, this is to identify electoral expenditure that a charity has made, which is money spent for the dominant, here we go, another adjective, dominant purpose of creating or communicating electoral matter. And electoral matter is something that's communicated to influence the way people vote. Now, we all know that as a charity, we cannot publish anything or say anything which has the purpose of telling people how to vote. Right? If you do that, you can get deregistered. You can say the Liberal Party has got these policies which we like, the Labor Party has got these policies which we don't like, or vice versa. So you can comment on the policies, but you can't be saying in your material, so we think you should vote Liberal and not Labor. If you do that, you get deregistered. And I think this is another way of capturing that, right? Because the ACNC is find it much easier now by pressing on this link to see where you've spent your money. And then they can start asking you questions about how you spent your money. So just be conscious of that. Yes.
So, but you can still attend their events and their functions, but you maybe want to be seen to be attending both sides, so that it looks like they're not going to pick you up if you've only attended one side.
No.
I was at a political function this week, and somebody from the childcare sector got up and read a pre-prepared question to the Premier about what he was going to do. Now, that was a paid function. So you can still do that, but it's about telling your donors how to vote. Is that
Yeah, and it's how you spend the money.
Yeah, right.
Right. So it's not just a matter of attending an event, because you could argue I'm attending the event because I want to hear about what that party's going to be doing about these issues,
right.
You know, in the upcoming election. Yeah. But if you go and give a donation of $100,000 to that party, that's going to get picked up.
Yeah, right.
Yeah. All right. Next change is, you would have probably heard, the ACNC legislation that created the ACNC came out in 2012. And these days, the practice is every act that comes out should be reviewed every 5 years. So I did a review of that. I know it's now 2021. Let's not count how many years it's taken, just the way things are. But, you know, that took a long time. And so there are all sorts of recommendations about how that actually be changed. 3 of them, amongst others, have been picked up and are actually going to now be implemented. I'm going to go through these 3. They've got to do with revenue thresholds, disclosing related party transactions, and disclosing remuneration. So the first one is, we all know that charities are classified as small, medium or large, and that depends on the revenue in a particular year. And it used to be 250 is small, between 250 and 1 million is medium, and more than 1 million is large. And people were complaining that the thresholds were too low, right? So they've changed the thresholds. We'll see what the new thresholds are, which has the benefit that more charities will be captured in this medium and more categories than used to be the case, which means the reporting is lessened, because the smaller you are, the less you've got to report. So I think this is a good change for charities, and this starts in the 2021 and subsequent financial years. So effectively it started, right? So that's beneficial, and it means that you should reconsider how you've classified yourselves and what reporting that then entails. The next one is remuneration. So this applies to large charities. So this now means if you're more than $3 million in revenue, right? So if you're more than $3 million in revenue, then, and you prepare special purpose financial reports, you've got to disclose the aggregate. That means the total paid in remuneration to your directors and your senior management, except if you only have one paid person, because obviously then people can work out what that person is paid. 2 or more people are paid, you've got to put into your reports, we paid a total of X dollars as remuneration to these people. And I'm not an accountant, there are a couple of different accounting standards that apply to this. Again, if you need more information, email me. There's one accounting standard that actually asks you to break it down between short-term employee benefits, long-term benefits, termination benefits, share-based payments and the like. It's a much more detailed breakup of what their remuneration was. The other accounting standard doesn't ask you to do that. But keep in mind, this is only for large charities, right? Not for smaller ones or medium ones. Related party transactions. Yes, I agree. I feel like grunting. Now, this is messy. It should be so much simpler than what it is, but it's messy because if you are a company, you've got requirements under the Corporations Act, and if you're a charity, you've got different requirements under the ACNC legislation. You need to comply with all of them. They've got different rules, different exceptions, and it's just a nightmare. However, there have been changes about this for charities. So this applies if you're a charity. It doesn't matter whether you're a company or an incorporated association, you need to be aware of this. A related party transaction is where you're giving something, whether it be money or a service or something, to a related organisation or a related person. That can include your directors and their spouses and the like. So it's a fairly wide definition. And if it is material in nature, we don't know what material means yet, we're waiting for some guidance on that, then it's got to be reported. So, sorry for all this text, but I wanted to make sure I captured everything. If you are a small charity, we now know that that means less than $500,000 in revenue. If you are a small charity, then you have to give a brief description in your annual information statement about your related party transactions. If you are medium or large, you've got to give much more information in the financial statements that are prepared and also in your summary in the annual information statement. This law, if you're already preparing general purpose reports, this already applies to you. But now it's also going to apply to those who prepare special purpose financial reports. So it's broadening. And this is going to start in 2023. Something to look forward to. All right. I'm conscious just after 10, so I'm going to rush through this. Fundraising. For those of you who fundraise in New South Wales, is that most of you? Yes? Okay. So, changes to the law happened earlier this year. They started on the 1st of July in 2021. And I'm just going to run through the main changes in case you haven't heard about this. There wasn't a lot of fanfare about this, and I think there are many charities out there that don't appreciate these changes that actually happened. One is you can now get a fundraising license for up to 5 years. I think it used to be 3 years before. And if you are registered as a charity with the ACNC, you automatically are able to get one. You still have to apply to get the license, but you don't have to show you're eligible. The fact that you're a registered charity means you can get this fundraising license. Is their attempt to streamline things. Next, if you are an ACNC registered charity, you only have to report to the ACNC. You don't have to give an annual report to Fair Trading. Again, an attempt to streamline reporting. There's an increase in penalties, which I'll get to. That's the exciting part, the fact that we can go to jail. Yes.
Other states. So if you're fundraising nationally.
All of them are following suit, right? They're all doing a similar thing. And some of them are actually ahead of us. They did this a while ago. One of the things that Fair Trading can now do is actually just issue penalty infringement notice, just a penalty notice like a fine, which I couldn't do before, right? So they're really cracking down. Why are they cracking down? A lot of this came out of the Bergen inquiry, right? The New South Wales RSL case you all would have heard about, right? All sorts of fraudulent activities going on. They did a huge inquiry and they thought, gosh, we've got to crack down on fundraising. And so this is now a result of all of that. And you would have remembered that you used to have your license, then you had these standard conditions sort of floating out there somewhere that you had to comply with. Those standard conditions are now contained in a new regulation. So we know where to find them now, which is good. There are updated reporting requirements, which I've got there, which you have to comply with even if you didn't receive any fundraising money, which is interesting. And if you raise more than $250,000 in a financial year, your accounts have to be audited. There's more regulation around transparency, which is all contained now in the regulation. Again, I won't go into that with you. That's all quite detailed. But please have a look at that because it could impact if you're contracting with people to fundraise on your behalf. Make sure those agreements are reviewed to ensure that they're now up to date with the new law. So have a look at all that. Trading agreements as well. If you've got trader agreements, for those of you who don't know what that is where you have an arrangement with a business usually, and they sell goods or services and some part of that goes back to you, that's a trader agreement, make sure that that agreement is up to date. Okay, so with the updated reporting, within 6 months after each financial year, you've got to give a written statement that during that year you have complied. So they want you to sign up that you've actually done the right thing in that financial year, that you've complied with the Act, the regs and so on. So that's your way of nailing yourself to the post. Obviously, you'd want to make sure you actually did comply before you sign off on something like that. And as an example of what can go wrong, we heard about the Celeste Barber case, where she obviously wanted to help during the bushfires, didn't really talk to anyone, went through a fundraising platform, didn't expect the level of support that she got. I think they're up to $50-something million. People were donating thinking that this money was going to help the families that were impacted by the bushfires. But of course, this was all going through the New South Wales Rural Fire Service, and lo and behold, once all the money was collected, they looked at what the New South Wales Rural Fire Service could use its money on, and it wasn't to help people who are victims of bushfire. So the New South Wales Rural Bushfire Service had to go to court. You can go to court if you're a trust, and you can go to court to get direction. So it's not actually suing someone. You can actually go to court, to the Supreme Court, to see a judge, to get directions from the judge about what do we do to make sure we are legally compliant. And the judge looked at the constitution of the rules for the Rural Fire Service and so on, and said, look, I'm sorry, but despite what the public thought they were donating to, based on the rules of the Rural Fire Service, you can only really help the firefighters, not the people who were impacted by the bushfires, which obviously was not ideal and would have been embarrassing for Celeste Barber, amongst others. So we need to be careful, and sometimes you can't control what individuals are going to do. They want to go off and fundraise on your behalf without even telling you that they're doing it, and then you end up with this embarrassing situation. So I think we need to be more alert to that, especially with these online fundraising platforms. People will start campaigns without even reading the rules of that platform. They get excited, they're passionate about a cause, they go in, they start the campaign, people donate because they're generous, and then it's only after the event that they realise, oh, I actually can't use this money that we've raised for the purpose that I thought it was, or there's some other loopholes or hurdles I've got to jump before the money can be used, and then the public get upset, and then the public think, well, why, especially with the Celeste Barber case, why didn't someone tell us this was going to be an issue during the fundraising campaign? Why did we find out at the end of it all? And it just gets embarrassing and awkward, right? So as a charity, it's hard, but there's got to be some way that we control how individuals with the best of intentions fundraise on our behalf. And ideally, they should be getting authorities from you, and you have that initial discussion. Yes, Vera, we'd love for you to fundraise for us. However, these are the rules, and you need to appreciate that any money you raise can only be used for this and this and this purpose. And then penalties. The penalties have gone through the roof if we're going to breach the fundraising laws. The penalties are much higher, and there are prison sentences if we really do something egregious. Okay, and finally, the last one, I said I'd finish off with the public ancillary funds. They're changing the guidelines. The public ancillary fund, as I said, is a foundation of sorts, where the public is invited to make donations to this foundation, and then the foundation promises each year it's going to invest that money. It's like an endowment fund, and each year it's going to distribute a certain percentage of that money to an item 1 DGR, which is a deductible gift recipient actually doing charitable work, right? So an example is, Mills Oakley sets up, it's called a PAF, invites all the employees and families and clients to put money in, and then Mills Oakley decides at the end of each year, this year, with all the money that we've raised, we invested it, and we're going to distribute 10% of the money we've collected to, we're going to focus on disability this year. Next year, we're going to focus on the arts or whatever it is, right? So it gives the PAF the flexibility to decide strategically what they want to do with that money. The guidelines are quite old, they're about 10 years old. So Treasury is looking at updating them. I think the deadline to make submissions is today, if you want to have a look and write anything in. One thing that's right, go back and do that, yes. Just grab some food before you go. And one thing that we picked up on was that because the guidelines say that you have to distribute a certain amount of money each year, sometimes that is just practically difficult for a PAF to do that. And they could write into the ATO and say, from this and this reason, can you please give us permission to distribute less? You know, COVID happened, our fundraising didn't happen the way we wanted to, and so you ask for permission. And the commission just writes back and says, yes, I agree, no, I don't agree. Now the PAF guidelines, if this gets passed, will allow the PAF to actually appeal that decision. So the commission says, no, I don't agree with what you've said, you're still going to distribute the minimum 4 or 5%, then the PAF can actually take it further. Right, so that's interesting if you run a PAF. Anyway, I am going to stop there before I run out of voice. So any questions, anything that I didn't explain well enough? Can you see there's a lot there? There's a lot happening. And I feel as if COVID sort of stalled things and now suddenly it's all just happening. All right, well, thank you very much. Take any materials you want. We've got more materials there if you want them. Grab some food. If you want to stick around and have a chat, do that. But otherwise, thank you for joining me. Thank you.